All right, here we go. This is Clayton County Magistrate Court preliminary hearing calendar. Today's date is June 11th, 2025. This is the matter of the state of Georgia versus Paul Hamilton Mouton, warrants numbers 2025 WA 73972, 7374, 75, 76, 77, 78, 79, 80, 81, 83, 84, 85, and 2025 WA 73997. All parties are present and have announced ready to proceed. Ms. Thomas, you can begin.
Yes, Your Honor. Lieutenant, could you please raise your right hand? Do you solemnly swear and affirm that the evidence you're going to give before the court this morning shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down, state your name for the record.
Lieutenant Jonathan Carey.
How are you employed, Lieutenant?
Clayton County Sheriff's Office, Black Hawk Unit.
And were you so employed on March the 21st of 2025?
Yes.
And on that date, did you come to have occasion to investigate an incident that occurred in the vicinity of Riverdale Road and Forest Parkway?
Yes.
And is that within the confines of the city of Riverdale, Clayton County?
Yes.
And did that incident involve a Paul Hamilton Mouton?
Yes.
And what brought your attention to Mr. Mouton? Well, before I get there, what is the Black Hawk Unit?
Black Hawk Unit is basically the Sheriff's Office traffic unit. So we investigate any traffic infractions, DUIs, stolen vehicles, things of that nature.
And this originated from a traffic incident?
From a traffic stop, yes.
Okay. And having said that, what brought your attention to Mr. Mouton? What happened?
Lieutenant Warren, who's the lieutenant for the BAT unit, advised that he was.
Okay, let me stop you right quick. What is the BAT unit?
The BAT unit is burglary, auto theft, and truancy. So their main job is traffic enforcement as well, but they're more in depth with burglaries and auto thefts.
So you all have overlapping responsibilities?
Yes.
Okay. Now, what brought your attention to this gentleman, Mr. Mouton?
Lieutenant Warren advised that he was conducting a traffic stop on I believe, a black Kia or Hyundai. I believe it was Kia. He advised that the vehicle was not stopping and that the driver was now taking off and pursuit. And I was in the area of Riverdale Road and Forest Parkway when I observed that vehicle recklessly fly past me.
When you say recklessly fly past, how fast was that vehicle going?
I estimated the speed to be at least about 70 or 80 miles an hour.
What is the speed limit in that particular area?
On Riverdale Road, the speed limit is 45.
So was he in excess by how many miles?
At least 30 over.
And was this the vehicle that was described to you by Lieutenant Warren?
Yes.
Okay. What did you do next?
I then became the second vehicle in the pursuit. We got onto Interstate 285 and began driving eastbound on Interstate 285.
Is this still, within the confines of Clayton County?
Yes, it is.
Okay. And you say you're eastbound on 285. What happened next?
So we're eastbound on 285. We're approaching Interstate I-75. The vehicle is now driving on the shoulder, the left-hand shoulder, driving past cars, cutting vehicles off, following too close as well to other vehicles. At one point, once we passed over I-75 and approached Old Dixie Road, I became the primary vehicle. With my training of performing pit vehicles, I went ahead and performed a pit maneuver to protect the public.
Were you able to stop the vehicle?
Yes, I was.
Okay. Now, before you performed the pit maneuver, about how fast were you all going?
We're at least over 120 miles per hour.
What is the posted speed limit at that location?
65.
So what, 40 miles over perhaps?
Yes.
Okay. Now, when you performed the pit maneuver, what happened to Mr. Mouton's vehicle?
I pitted him on the left side of his vehicle, which caused his vehicle to go to the left and crash into the center median wall, dividing wall.
And is this on 75 or is it still on 285?
Still on 285.
Okay.
Near Old Dixie.
Okay. And when the vehicle hit the median wall, did it stop or did it keep going?
It immediately stopped it.
Okay. What happened next?
I went up, I had to make a U-turn to come back. We then placed the vehicle at gunpoint and got the passenger and the driver out. The driver had to be extracted through the window due to another vehicle being pinned up against his driver's door. He was taken into custody without incident, and the passenger was taken into custody without incident as well.
Okay, let me stop you right here before we get too far. You said that when you did the pit maneuver, it slammed into the median wall?
Yes.
And you just said that you had to extract him out of the window because of another vehicle. What was going on with the other vehicle?
Yeah, so when you do a pit maneuver, it's pretty much a pit and pin. So one vehicle will perform the pit maneuver. The other vehicle will pin that vehicle, basically to prevent it from going further.
So another patrol vehicle?
Yes.
Not a citizen minding their own business?
Correct, another patrol vehicle.
Now, when all this is going on, were there other cars out and about on the expressway?
Several.
Okay. And during up to this point, was any other vehicle struck or was anyone else injured?
No vehicles were struck. There was one more person injured that was inside.
Inside? Is that what you just said?
Yes.
Okay. So let's go back to where you left off. You were able to get the defendant out through his window?
Yes.
He was the driver?
I'm sorry. Other deputies were able to extract him through the window.
Okay. So it was not just you. It was other deputies, and I'm assuming other law enforcement out there assisting?
That's correct.
Okay. While you're turning around, they get him out?
Yes.
You indicated that someone else was also detained?
Yes, another female front seat passenger.
Okay. What was going on with her?
She was just the front seat passenger. She was just hysterical. She was advising several different things.
What did she advise as to how she ended up in that vehicle?
She advised that she was already, of course, in the vehicle. She was in the vehicle willingly. However, once the pursuit started, she was telling him to stop, let her out, and the young child that was in the back seat, let them out, but he refused to pull over.
So she was being held against her will at that point?
Yes.
Now, you mentioned a third person that was injured. Was that the child you just mentioned?
Yes.
And how old is this child?
I want to say I don't have kids, but probably no older than 3.
It's a very small child.
Yes.
And was the child secured in the vehicle in any type of way?
She was in a car seat.
Okay. Now, how was she injured?
She had a knot on the front of her head from, I'm assuming, maybe hitting the seat that was in front of her.
Was any glass shattered as a result of the collision or the chase itself?
Yes.
Did any of that glass hit the child?
Not that I know of. No.
Okay. What about the front seat passenger?
The front seat passenger, no, but the driver, yes.
And is the driver the father of the child?
That's what we were told on scene.
And who told you that?
The female.
The front seat passenger?
Yes.
After extracting the front seat passenger and the child, one second, John, he's got quite a few. I see you've charged him with speeding 35 miles per hour and super speeder. What is the basis of those charges?
Super speeder is basically driving 85 miles per hour or more on the interstate.
And I believe you testified previously he was operating his vehicle in excess of 128 points.
Yes.
And you indicated also it was too fast for conditions. What was the basis of that?
It was about 6:20 p.m., so it was moderate traffic.
And I see the 2 counts of kidnapping. Is that based on the passenger's statement?
Yes.
and the child was hers?
Yes.
Did she ask the defendant to let her and the child out, or just her?
Her and the child.
Did he refuse to do so?
Yes, he did.
At any point in time, did he even attempt to pull over and let her out?
No.
Did he make any statements to you all regarding what happened?
Not to me, or that I heard. So no.
Did he make statements to anyone that you know of?
Not that I.
Were you all equipped with body cam? Well, I should say with you first. Were you equipped with body cam?
Yes.
And did it capture any conversations you may have had?
Yes, it did.
Where is that body cam footage now?
It's stored in our cloud on evidence.com.
So it's available to the sheriff's department?
Yes.
The other officers who assisted, do you know if they were equipped with body cam?
They were.
Do you know where their body cam footage would be?
They would be in the same cloud as well.
Okay. You also have this gentleman charged with disregarding a traffic control device. When did that occur? Or what device did he ignore?
That occurred on Riverdale Road. The device that he ignored was the red light when he came through Riverdale Road, northbound, passing Forest Parkway. The light was red at the time.
He blew the light?
Yes.
Were there other individuals operating vehicles on the road at the time that he did that?
Yes.
Would that have been placing their lives in danger by blowing that light?
Definitely, yes.
And you also have in charge of improper driving on divided highway and improper lane change. What brought those two charges about?
The improper lane change, she was erratically changing from lane to lane to get around vehicles to evade us. Also, the divided highway restrictions was him driving on the shoulder of the interstate, and then at one point driving within the gore of the interstate.
Okay. And is the interstate considered a divided highway?
Yes.
Another count you have, failure to secure seat safety belt on a minor. Now,
Yeah.
Just a few minutes ago, you indicated the child was in a car seat, or was she?
She was in a car seat, yes, but she was not buckled up.
So she's just sitting in the seat, but not connected to anything?
Yes.
Would that be considered a projectile?
I'm not sure. Wait.
Would the seat protect the child if it was not strapped in?
So the seat was buckled in, but she didn't have straps around her body to protect her from a crash if one was to occur.
Okay, I misunderstood. So the seat itself was buckled in, but the child was not buckled into the seat.
Correct.
Okay. And was he wearing a seatbelt?
No, he was not. It was behind his back.
And I believe you previously testified the child was injured as a result of this?
Yes.
What was her demeanor?
She was crying. She was hysterical. When I got her out the car, I calmed her down. So she definitely didn't know what was going on at the time.
Okay.
And scared.
And was it her mother had a similar demeanor?
Yes.
At any point in time, did he ever attempt to comply with officer efforts to stop him? Was a traffic stop? Did he ever do that? That you could tell?
In the very, very beginning of the traffic stop, yes. He initially pulled over for about 10 seconds, and then he took off.
Now, when he had pulled over that first time, could he have let the passenger and the child out?
He could have, yes.
But he didn't.
Correct. He did not.
And one more thing, you indicated law enforcement was attempting to execute a traffic stop, correct?
Lieutenant Warren had activated his emergency license sirens to pull the vehicle over.
Were your emergency license sirens operable?
Yes, it was.
And were they working? Were you using them in this attempt to stop him?
I was not there for the initial traffic stop. I was further down the street.
Okay. But when the pursuit began, did law enforcement have active lights and sirens going?
Yes.
And I believe you said he attempted to stop one time. That's it?
Just one time, yes.
Okay. And I actually believe that covered everything. Reserve right for redirect.
All right, Attorney Bowles, do you have cross-examination?
Your Honor, just a couple of things I want to focus on. Good morning, Lieutenant Carey. So I've got, I want to focus real quick on the seatbelt violation for under 8 years old. So you said there was a car seat that was actually buckled in, correct?
Yes.
Okay. The vehicle was pitted. Were you the first person to approach the vehicle?
No, I was not.
Okay. When you did approach the vehicle, were you able to see where the child was?
Yes.
Where was the child?
The child was in the back seat on the passenger side.
Was the child was the child sitting in the child's seat, just unbuckled?
Yes.
Okay. Did you ask Mr. Mouton if he had attempted to unbuckle the child at any point after the vehicle was pitted?
No, I did not.
Did you ask the mother that question?
No.
Okay. Just when you approached the vehicle, you saw that the child wasn't restrained in the child safety seat.
Correct.
Okay. See here. Y'all covered most everything. I really just have a lot of argument, but essentially, I think the only charge that Madam ADA didn't specifically address is the obstruction, and I'll just let you elaborate on that. I know what it is, but I'll let you elaborate.
Me?
Why did you charge obstruction?
Oh, I charged him with obstruction because he hindered our investigation from determining whether we knew that he was wanted for fleeing and looting from Henry County Police Department, but when we conducted a traffic stop to further investigate, he did not comply.
Okay, so that's a new fact. So the vehicle was actually being stopped based on what, a warrant?
Based on a warrant, yes. Based on the vehicle not having intent on the vehicle, us having knowledge that the driver is wanted, and us having a picture of the driver, knowing that he is the one, in fact, driving the vehicle at the time.
Was the vehicle associated to Mr. Mouton?
Yes, it was.
Was it alleged to be the same vehicle that was in a fleeing and eluding in Henry County?
Yes.
Okay. I don't have any further questions.
All right, any follow-up, Ms. Thomas?
No, Your Honor.
All right, does the state rest?
Yes, Your Honor.
All right, any evidence or witnesses on behalf of the defendant?
Just argument, Your Honor.
Okay, Ms. Thomas, are you deferring to Mr. Bowles to begin his argument?
Yes, Your Honor.
All right, I'll hear from you, Mr. Bowles.
Yes, Your Honor. So there are two charges I want to, well, I guess technically there are three charges I want to specifically focus on. The kidnapping, both counts of kidnapping, and the cruelty to children in the third. And I'd also like to talk about the seatbelt violation for under 8 years old. So specifically in regard to the kidnapping, Your Honor, it's just statutorily incorrect that this be charged as kidnapping. The kidnapping statute reads, and I quote, "A person commits the offense of kidnapping when such person abducts or steals away another person without lawful authority or warrant and holds such other person against his or her will." That's conjunctive. That's and. The first element of that statute is not met because the mother and the child were in the car and consented to being in the car prior to the incident. But furthermore, Your Honor, Section B1 of the kidnapping statute specifically outlines for the offense of kidnapping to occur, slight movements shall be sufficient, provided, however, that any such slight movement of another person which occurs while in the commission of any other offense shall not constitute the offense of kidnapping if such movement is merely incidental to such offense. Your Honor, that's exactly what we have here. That's outlined. It's statutory. It's not accurate. It cannot be charged as kidnapping. To establish probable cause on kidnapping would just be an accurate statement of the law at this point. Based, for one, on the idea that they were consensually in the vehicle prior to the alleged fleeing and eluding occurring, and also based on the way that it's being charged and described to the court, that the kidnapping then thereafter happened because Mr. Mouton didn't stop the vehicle and let them out. Our legislature has considered precisely such a situation in Section B1 of the statute, and this cannot be kidnapping. I ask that neither count of kidnapping be bound over. Your Honor, in regard to the cruelty to children, we can really at this point only infer what is intended or meant by probable cause for cruelty to children in the third. There wasn't anything specific in regard to physical or mental anguish. Of course, within the confines of the fact pattern, there is an inference that can be made there, but it's not the job of a probable cause hearing or the intention of a probable cause hearing to make inferences. That's why we specifically have to go through each of these charges, and Madam ADA does a great job of doing that. I'll list all of these charges out and put a check mark beside them, and I think she probably does something very similar. But there wasn't anything specific given in regard to cruelty to children in the third, in regard to establishing physical or mental anguish for the child. We cannot simply just infer based on any set of circumstances that would have happened. There has to be testimony offered during the evidentiary period to establish probable cause for such a charge, and that has not occurred.
What about the knot on the head? What about the knot on the head that the officer testified the child sustained?
I apologize, Your Honor. I meant to turn the volume up and I turned it down. What about what now?
I was saying, what about the knot on the head that the officer indicated that the child sustained as a result of this?
Your Honor, I did not have that in my notes. There was testimony in regard to a knot on the child's head.
Yeah, he said that the child sustained a knot on his head, and then she also asked about the glass, but he said that the child didn't. He didn't see any glass on the child, but he only testified that there was a knot on the head.
Okay, and Your Honor, there isn't any testimony in regard to the to whereabout this child would have received a knot on their head. Again, Your Honor, we can't exactly infer that happened during the collision. In fact, the testimony was that the child was still sitting in the child's seat, though the child was not restrained. And I specifically asked the question, did you ask either one of them if they had unbuckled the child after the vehicle had been pitted? And Lieutenant Carey indicated he did not. It sounds to me like, based on the nature of the vehicle being pitted and what I would imagine was a severe wreck, the child wouldn't have remained in the restraint seat. And I think without testimony as to why we believe the child had a knot on their head, or asking either person, asking the mother if the child had the knot on their head before the vehicle was allegedly involved in this fleeing and eluding, I think we have a testimonial issue there. If there was some testimony about it, it certainly could be established for the purpose of probable cause at least, but we didn't have that testimony, only that there was a knot on the child's head. So I don't think that just simply saying the child had a knot on its head without having any relation or testimony for approximate cause of that injury can establish probable cause for cruelty to children. And then last, Your Honor, is the seatbelt violation. Again, same argument in regard to cruelty to children as well. No testimony that at the time the vehicle was in motion, the child was safely restrained within the confines of the child safety seat. And I think it's evidence that that is exactly what the case was by the fact that the child was still in the seat after what's been described as a pretty violent pit maneuver in the vehicle. So, Judge, I'm asking that the seatbelt violation for the 8-year-old, the cruelty to children in the third, and both counts of kidnapping not be bound over.
Okay. Ms. Thomas, for the purposes of argument, you can just address the ones that he's actually requesting to be dismissed.
Now, that would be the kidnappings, and I believe
Seatbelt and cruelty to children.
children. Yes, Your Honor. That would be warrants 80, 81, and 82. Regarding the 2 kidnappings, Your Honor, Mr. Bowles has an interest in interpretation of the statute. However, there is a separate section that says movement is not considered merely incidental to another offense if conceals or isolates the victim, which happened here. This lady literally could not get out of the car. And it's for the purpose of avoiding apprehension, which is exactly what happened here. I believe the lieutenant testified that this gentleman pulled over for a very brief moment. He could have let her and that child out at that time. He declined to do so. He accelerated and continued the chase. There is a case specific to this situation, ironically. It is Pruitt versus the state, 279 Georgia, 140, 611 Southeast 2nd, 47, and it's a 2005 case. It states the fact that the victim voluntarily got in the defendant's car, which this victim indicated she did not change the fact that a kidnapping occurred when the defendant then drove the victim, in this case, from the city of Atlanta to Alabama, despite the victim's repeated protests. That's exactly what happened here. This lady was trying to get out of the car. She indicated that to the officer that she told him she wanted out of the car, and he refused to stop. He did not let them out. They did not. She and the child were not able to get out until the officer performed the pit maneuver, which forced the defendant to stop his vehicle. Now let's talk about the cruelty to children in the first degree. The officer indicated that he saw a knot on the child's forehead, which he took to have been inflicted as a result of this chase and the dramatic ending of it. He indicated that when he took the child out the car, he was able to get the child out of the car. The child was not buckled in, that the child was very upset, and he had to calm the child down. Your Honor, if that's not cruelty to a 3-year-old who has no idea what's going on, I don't know what is. The mother and the child were both extremely upset. The mother and the child were not allowed to exit the vehicle, which put both of their lives in danger. And Your Honor, I believe those are the primary. Regarding the obstruction, I believe the officer did adequately cover that in his testimony.
But, yeah, he wasn't challenging that.
Yes. So I believe the 3 warrants that were being challenged, 80, 81, and 82, were all covered by the officer's testimony, simply by virtue of the fact that the mother indicated she told him to let her out, and he refused. And all of this, including the cruelty in the first, occurred as a result of his refusal to let her out. State would contend at this point there has been more than sufficient evidence to show that all these counts should be transferred to the Superior Court of Clayton County.
Okay, I'm looking at the Pruitt case, so I'll be able to rule on those kidnapping charges. So give me about 2 minutes to read this. So court will be in recess for about 2 minutes.
Yes, Your Honor.
Okay, court back in session. I had an opportunity to review the Pruitt case that was cited, and it does actually address this and makes it a jury issue to determine whether the person that expresses that they want to leave the car after they voluntarily entered is a matter for the jury. So based on that, the court will find sufficient probable cause for all the charges, including the kidnapping, except the seatbelt charge. Everything else will be bound over to Superior Court for further prosecution.
Understood.
That is adjourned.
Thank you, Your Honor. Thank you, Lieutenant. You're excused.
Mr. Bowles, you were saying something additional?
No, Your Honor, that concludes my business. Can I be excused?
Yes, sir, thank you.
Thank you.
Okay, the court will now be in recess for everybody to do pretrial conferences to speak either to your clients or Ms. Thomas. And we're gonna do the breakout rooms. So if anybody would indicate to me if they would like to speak to Ms. Thomas first, or then I can set that one up and get you in that breakout room. And or if you want to go to the jail first.
And I do believe Ms. Boykin has her hand up. Ms. Boykin, can you turn on your camera right quick?
Yep, I'm here.
You want the jail or Ms. Thomas, Ms. Boykin?
Miss Thomas.
Okay, and Mr. Charles?
Miss Thomas.
Okay, all right. So, all right, we'll get that set up. And all right, court will be